Hello, everyone, and welcome to week number 7, criminal investigation. And this week's topic is going to be defense attorneys. Part of the process of keeping our legal system on track is to have everybody have the right to have an attorney. In some cases, if a person has money, they can go and hire their own attorney. Other cases, where people don't have the money, you're going to get a public defender. We're going to look into both of those. But one thing that happens is oftentimes people can say to an attorney, how can you be a defense attorney? You know, if a person's guilty, they're guilty, and we're going to find them guilty, we're going to put them in jail and lock them up and throw away the key. As we've seen earlier, is that sometimes a person gets convicted or confesses and they're really not guilty. And the other times, as we unfortunately saw and have seen, is that sometimes the prosecution or the police or another investigator fabricates things. They don't share the evidence. They do all those types of things there, and we need somebody to represent people, particularly if a person is facing a felony sentence. So when you look at a defense attorney, you want to look at the fact that the defense attorney is there to make sure that everybody is playing by the rules. Just like the judge, where the judge is going to make sure that he or she is going to be the referee in a case, is that a defense attorney wants to make sure that his or her client gets their rights under Miranda, gets their rights as far as search and seizure goes, gets the rights to make sure that the proper policy and procedure has been followed. There are good defense attorneys, and there are not so good defense attorneys. Same thing that happens in policing and judges and prosecutors. But what we want to look at here is qualities of that, and also the fact that when a person needs an attorney, is that there are certain situations that occur, and when a person really needs one, and to be able to utilize that fact in doing those things. So I put together a little program here as to a person's right to counsel. We know that the minute that we go from the accusatory, get to that accusatory stage, that the person is going to be possibly arrested and denied their freedom, is that they're going to have a right to counsel under Miranda. One big case was Gideon versus Wainwright back in 1963. Gideon requested a court-appointed attorney. He was refused. He had unrepresented by counsel. He himself wrote a handwritten note to the Supreme Court, and the Supreme Court ruled on it, saying that indigents, people without the money, have the right to court-appointed counsel, and particularly in felony proceedings. And it started to send, as the slide says, shockwaves through the criminal justice system. It also happened with juveniles. In the 6 months that the right to counsel was extended to juveniles in Ray Galt in 1967. Mr. Galt made some what was at that time considered obscene phone calls to a neighbor. The neighbor called the police. The police went and picked him up, went in, didn't advise him of his rights, got a confession from him. He never notified the parents or anything like that, and that resulted in the fact that even a juvenile has those things there. And there are a couple other, you don't have to know these cases here, but there's, as we progress through the years, there's more and more the need for a attorney, even in a non-felony prosecution. That is, if you're going to get charged with a misdemeanor, but the misdemeanor has a jail time with it in doing those things. So when a person under arrest, is that there's really no lawyer required unless the person requests it under Miranda. When a person starts to go before the judge, for that is that the lawyer is required. And this is where that all kicks in there. When we look at bail, is that a lawyer is required at that stage. As far as being charged, the lawyer is not required because that's the job of the prosecutor in doing that. However, once that charge has come down and the person has either turned themselves in or been arrested, is that the preliminary hearing is that you're going to need a lawyer. When the grand jury is impaneled, is that there's no lawyer allowed in the grand jury proceedings. But we can see right now there's a case that's happening with the shooting of a young woman, and the grand jury is being challenged as to what they had and what the prosecutor does. So a lawyer can come in after the fact and request to look at the transcripts. After the grand jury has come down with what's called a true bill, that person's being charged with a crime, is that it's incumbent upon the prosecution to turn over the transcripts. And this is where a defense attorney would go over that. When the person is arraigned on those charges, then a lawyer is required again. When a person is becoming interrogated, again under Miranda, is that if the person requests a lawyer has to be present during those interrogations. So the same thing happens when a person is either out on bail or is in jail waiting a trial, and they're going to be interrogated again. After they've been indicted, a lawyer is required. There's no lawyer if the prosecution decides to go through with a lineup. But if prior to being arrested, after the person's arrested and they're going to be required by a search warrant or anything to be in a lineup, then a lawyer is required there. Obviously, when we start to have a plea bargain, when the prosecution is going to get together and come up with a plea bargain rather than go to trial, obviously you need a lawyer that's there. When the trial starts, again, a lawyer is required. When the person either pleads guilty or they're found guilty by a jury, that's another incident where a lawyer is required. When a person's out on probation and the probation is going to be revoked, there's a discretionary fact from the court as far as a lawyer. Same thing holds true as parole. When a case goes on appeal, and this is particularly in a lot of felony cases, in particular a murder case where there's an automatic appeal, obviously you're going to have a lawyer on there. However, once if the appeal has been denied and it's going to go on to a next thing, so you're going to go to the appeals court or anything like that, there's no requirement for a lawyer, but oftentimes it is suggested for these particular situations. So these are a lot of things that happen when a lawyer gets into the ballgame. This is particularly with a defense attorney in doing those things. So that's just a quick overview of those things that we looked at in doing those things. And we're going to go through this lesson here. I've got some very, very good interviews on videos that talks about a defense attorney and the rights of a defense attorney and all those things there. So as we move along into this section of the class looking at the defense attorneys, I hope that you get some understanding of the challenges that a defense attorney has, of the need for a defense attorney, of the fact that a defense attorney can do things. There's one other interesting thing that's be in this module is that with now using media, is that there's a section there about a new thing where defense attorneys are becoming involved in multimedia, and when they go to make an appeal to the judge, is that they're getting people and creating scenarios to try and impact the judge's decision when he or she's going to make a determination for sentencing of a person. It's a pretty interesting concept that's out there for that. So I hope you get some understanding on this, and I look forward to looking at your replies. There's some questions at the end of the module where you're going to have to put your thinking cap on and make some decisions on your own regarding defense attorneys. So other than that, have a good week and stay safe and healthy out there. Take care.